everyone, and welcome to this 11th edition of Soundbites. My name is Stephen Reagan, and I'm the Principal Privacy Consultant and Subject Matter Expert on Privacy and Data Protection at Rangu. At Rangu, we provide flexible software solutions for integrated risk, security, and privacy management. We were founded in 2016 with the mission to deliver software solutions to manage privacy and compliance challenges. We've delivered over 200 projects in GRC, security ops, and data privacy across 18 industries and 15 countries. So with these sound bites, I just like to give a little update on what's going on in the privacy and data protection world. It's been a while since I've done one of these, so now is definitely no exception. There is a lot going on. So today I'm going to talk about the UK and some of the proposed reforms to the United Kingdom's version of the General Data Protection Regulation. Now that the UK has left the European Union, they have decided and are quickly moving towards adopting a reformed data use and data protection regime, really seeking to become a world leader in charting how data is used, and that involves data transfers, of course. So the UK left the European Union with an adequacy decision, meaning data can continue to flow freely between the European Union and the United Kingdoms. Now the United Kingdom has its own form of adequacy that it can give to other countries, and it is moving forward with the process of doing that with some targeted regions. So we'll touch a bit on some of the UK's reforms, looking at the standard contractual clauses. In particular, I will note that the European version and the United Kingdom version will not be the same. And a quick note for European organizations, on September 27th, all new data transfers will have to use those updated European version of the standard contractual clauses. The United Kingdom has decided not to adopt the European version, and so is currently in a consultation period. That will end on October 7th. After that time, there will be some deliberation and then the promulgation of the United Kingdom's versions. From just the standard contractual clauses, a very small area within data protection, the UK is also proposing to reform its overarching GDPR and recently administered a 150-page report on some proposed changes. That is also in the consultation period, and that period will last into November. So we'll touch on some of the details within the proposed reforms. And then from there, I will also look at the Chinese privacy law. On October 20th, China passed its version of the Personal Information Protection Law. Organizations and businesses that operate in China will have to adopt new provisions, new safeguards, new compliance tools in order to comply with that regulation by November 1st of 2021. That is when that law will go into effect. So we'll touch on some of the details within that legislation. And for organizations who operate in the EU or comply with the GDPR, there are some reassuring similarities. So your organization will not have to do a complete overhaul to operate in China. And then from there, I will look at the fine administered by the Data Protection Commission in Ireland of WhatsApp. In particular, some of the details of the fine that totals 225 million euros. So a really big fine, but I'm going to look a bit more at why WhatsApp was fined, really looking at in particular, the Article 13 and Article 14 privacy notice requirements and what information organizations have to provide to data subjects in order to collect and process their personal information. And then a bit of some of the challenges or the obfuscation of the data sharing agreement between WhatsApp and Facebook. Turning first to the United Kingdom, who has issued a number of draft proposals to update their data protection regulations and rules. In particular, the government is hoping to boost growth, increase trade, and improve healthcare. Along with that, the UK government has estimated that £11 billion worth of trade goes unrealized due to barriers to data transfers. In particular, the government has highlighted a number of priority territories to strike adequacy decisions and partnerships with, and those territories include the United States, Australia, South Korea, Singapore, the Dubai International Finance Center, and Colombia. So I want to pause for just a moment and discuss this a little bit. So the adequacy decisions, the adequacy mechanism is one way for organizations to transfer data from one territory or jurisdiction to another. Of course, the European Union, GDPR, has this mechanism as well. And not too long ago, the UK was going through the process of getting an adequacy decision from Europe. Europe's adequacy decision was based on the UK GDPR being essentially equivalent with that of the European Union. When the UK split from the EU, they adopted the adequacy decisions that Europe had already made on around 12 countries or territories. Now, the UK in the UK GDPR has a similar mechanism for transferring data without any additional safeguards, such as those standard contractual clauses or binding corporate rules or derogations. So the UK government wants to be a hub of data innovation, and in order to do this, they want to facilitate an easier environment for organizations to operate. One way to do this is to make it easier for organizations to transfer data from the UK to other jurisdictions, in particular those ones that I've just highlighted. Now, the UK adequacy decision from the European Union was based on this essential equivalence. There was a review process put in place, so there is a 4-year sunset clause on the EU's adequacy decision for the UK in which the UK's rules and regulations would be reviewed. That being said, it doesn't have to be 4 years before the EU reviews the UK laws. So as developments happen in the UK, with one eye, we need to be keeping watch for what Europe is doing and how they will respond to the UK's proposals. Okay, many of these jurisdictions, they don't have adequacy. The jurisdictions the UK has highlighted don't have adequacy determinations from Europe. So the UK is going ahead and making their own determinations. And one of the big issues and worries was for Europe was related to onward transfers of European data subjects and European data going from the EU to the UK and other jurisdictions. Most prominently highlighted, of course, is the United States, who had an adequacy determination through the Privacy Shield that was invalidated by the Court of Justice of the European Union in last July. So again, this was a real key issue that European regulators and advocates were discussing, is whether or not onward transfers would be facilitated by the adequacy decision for the UK, and then the UK going on and making its own determinations for other countries. So now we don't have a strict timeline for when these adequacy decisions will come out, or even if they will, or even if they are a certainty to result. But one real cause for concern for interested parties. That being said, this will make and create an easier environment for organizations and businesses to operate in. Now, that is one of the key tenets that the UK is trying to facilitate with the evolution in its laws. It's really trying to position itself as a dynamic data hub, able to, in some sense, leapfrog over the EU's adequacy plans, gain this first mover advantage, become an attractive jurisdiction for organizations and businesses to operate in, and bring their business, and with that bring their money. So again, this is one of the real motivating principles: create a more business-friendly environment that will attract business and boost the UK data hub, data sector. Along with this, on September 10th, the Department for Digital Control, Media and Sport that regulates data transfers for the UK. They published a consultation on reforms to the UK's data protection regime. Now, this was a 150-page document that is now in a consultation period, so concerned parties, businesses can send in notes or advice or reactions to the proposals. And this consultation period lasts until November 19th of 2021. Some of the key points from the proposal that I want to highlight, it's about 7 points. The first being that the government claims the reforms will net monetize benefits of £1 billion annually. The UK government believes that it is perfectly, again, along with this discussion of what the EU will do and how it will react to the UK's decisions and development, the UK government believes it is perfectly possible and reasonable to expect the UK to maintain EU adequacy as it begins a dialogue about the future of its data protection regime and moves to implement and reform in the future, end quote. So the UK thinks that it can do this while maintaining its adequacy decision from the EU. Again, time will tell. The United Kingdom government is also proposing a whitelist of activities that organizations will be able to do without conducting a balancing test for legitimate interest as a legal basis. So currently, legal basis of legitimate interest requires a balancing test of the threats to the rights and freedoms of the data subjects balanced against the business interests of that processing activity. What a whitelist is, it would allow the use of legitimate interest for certain types of processing activities without conducting this balancing test, making it easier for organizations to process data, in particular under that legal basis. Along with that, and again in this kind of deregulatory environment of proposals, the UK has proposed using personal data more freely for the purposes of training and testing AI and machine learning. So really looking to make it easier to develop innovative technologies. And along with that, the UK has proposed to amend the right not to be subject to a decision based solely on automated processing. So currently under the EU GDPR, Article 22, data subjects who are subjected to a decision, like a legal decision, for example, whether or not you get a loan, based on automated processing, the data subject can object to that. And this kind of protection keeps a human in the loop of decision making, meaning machines are not the only ones making this decision. There is also a human involved in the process. The UK is proposing to eliminate that requirement, allowing just for the automated decision making to take place without the human, using AI and innovative technologies. The UK also proposes to define a clear test for determining when data can be regarded as anonymous. Anonymous data means it cannot be identified with an individual. There are a lot of concerns with re-identification of anonymous data. One thing is that if data is determined or deemed anonymous, it falls outside the purviews of the GDPR and all of the requirements therein. The sixth point I wanted to highlight is the potential removal for the requirement of a data protection officer. And then the seventh point that I want to highlight is introducing a fee requirement for data subject access requests. So when organizations receive data subject requests, it's a time-consuming and resource-consuming process. And individuals can do that in the current state for free. That means individuals can make as many requests as they want, and the organizations, in most situations, have to comply. Under the UK Data Protection Act of 1998, individuals had to pay a £10 fee to make a request. This would likely reduce the number of requests that organizations face because individuals have to pay money then to facilitate their data subject rights. It seems a kind of a strange proposal that in order to enforce an individual's rights, they would have to pay money to do that. Nonetheless, it was a part of the UK's former data protection law and is now a proposal for the developments in current UK law. So along with that, the Department for Digital Culture and Media and Sport has also approved the appointment of John Edwards as the next Information Commissioner. Edwards currently serves as New Zealand's Privacy Commissioner, and he will succeed Elizabeth Denham when her term concludes at the end of October. The Information Commissioner is the head of the UK regulatory body responsible for enforcing data protection laws. New Zealand currently has an adequacy decision. Perhaps one of the motivations for getting Edwards into this position within the ICO, the regulatory body in the UK, is that he will be there enforcing the data protection laws. And one of the things the UK wants is to maintain its adequacy decision with the European Union. Edwards has experience as a privacy commissioner with a country with an adequacy decision, so operating within this purview of the EU, facilitating data rights, data protection law, that is to the EU's liking. So the UK, again, wants to develop as it will while maintaining that adequacy decision from the European Union. These proposals, these statements align with the government's intention really to empower Edwards, the new commissioner, to, quote, go beyond the regulator's traditional role of focusing only on protecting data rights, with a clear mandate to take a balanced approach that promotes further innovation and economic growth. So it's really, the UK is doing this balancing test, trying to promote economic growth while, again, maintaining protections for data subject rights, not favoring one over the other, but to a degree, again, that the EU finds satisfactory. The last point I want to make about the United Kingdom is that they are also undergoing a consultation period for updating their standard contractual clauses. Of course, the EU adopted their updated version of the standard contractual clauses, and for data transfers that are agreed to after September 27th, those new EU standard contractual clauses have to be used. The UK has decided not to adopt the European Union's version of the standard contractual clauses and is instead developing its own, called the International Data Transfer Agreement. That consultation period closes on October 7th. So again, skeptics may argue the trade-off for such an approach in the UK will be diluted data protection standards in the UK, creating greater risks to individuals' privacy rights. Time will tell whether or not the EU agrees with that sentiment and removes the UK's adequacy determination. But let's see what will happen. Turning next to China. So I've gotten a number of comments and requests to discuss the Chinese privacy law. It is top on a lot of people's minds, and for good reason. On August 20th, China passed the Personal Information Protection Law. This legislation will bolster individual rights in China and lay out an overarching regulation of data in China. The law will take effect on November 1st, 2021. This does not give organizations much time to prepare and implement compliance tools. The good news is for organizations who comply with the GDPR, many of the provisions in the Chinese privacy law, I will refer to the Personal Information Protection Law as the Chinese privacy law. Most of those provisions, many of those provisions, are adopted from the EU's GDPR. Now, a quick summary. The Chinese privacy law will operate in conjunction with the cybersecurity law and the data security law to form an overarching framework for the governance of data protection, cybersecurity, and data security in China. The Chinese privacy law specifically references the Chinese Constitution as the legal basis for the implementation of its data protection goals, with the official declared aims to protect the rights and the rights and interests of individuals, to regulate personal information processing activities, to safeguard the lawful and orderly flow of data, and to facilitate reasonable use of personal information. The Chinese privacy law adopts similar concepts and terms as the EU GDPR, including personal information, processing, and there are requirements for the processing of sensitive data and sensitive information similar to the GDPR. The Chinese privacy law also has principles such as legality, propriety, necessity, data minimization, purpose limitation, openness, and transparency. And the Chinese privacy law, again, has similar concepts to controllers, joint controllers, and processors. These concepts are, however, they have different terms or different labels. Controllers are called handlers. Joint controllers are referred to as joint handlers, joint handling, and processors are called entrusted parties. But those concepts, again, track on to the EU GDPR's versions of controllers, joint controllers, and processors. In addition, the Chinese privacy law will require data processing agreements between handlers and entrusted parties, similar to those requirements listed under Articles 26 and 28 of the GDPR. Now, the territorial scope of the Chinese privacy law, does it apply to your organization? The Chinese privacy law principally applies to organizations and individuals and handling personal information within China. Let me repeat that. The Chinese privacy law applies to organizations and individuals handling personal information within China. This means organizations or persons physically located within the borders of China. However, the Chinese privacy law also has an extraterritorial scope similar to that in the GDPR. So if your organization matches one of the following circumstances, you are also subject to the Chinese privacy law. Those are where the purpose of the processing is to provide products or services to individuals within China, or where the purpose of the processing is to conduct analysis or assessment of activities of individuals within China, or other circumstances provided in laws or administrative regulations. Of course, that last one is a little unclear. For organizations located outside of China, they must establish a dedicated entity or appoint a representative within China. Under the Chinese privacy law, there are legal bases for processing data, similar to those under the EU GDPR. Those legal bases include consent, necessity to conclude or fulfill a contract, processing by a legal obligation, processing for the public health, processing for journalist activities or in the public interest, information disclosed by persons themselves or other legally disclosed information within a reasonable scope, or other circumstances provided in laws and administrative regulations. Those are all of the legal bases for processing data under the Chinese privacy law. Notably absent is legitimate interest. Legitimate interest is not an approved legal basis for processing data under the Chinese privacy law. Again, the Chinese privacy law has an open list for sensitive data. There are also requirements that have to be fulfilled in order to process this data as well. In addition, the Chinese privacy law gives individuals certain data subject rights. These track on very well to the EU's requirements under the GDPR. In particular, the data subject rights under the Chinese privacy law include the right to know, decide, refuse, and limit the handling of personal information, the right to access and copy personal information, the right to correct or complete personal information, the right to delete information, the right to request handlers explain their handling rules. So this should be included in your privacy notice, and the right to data portability. Again, data subject rights under the Chinese privacy law track on really well to data subject rights under the GDPR. And there's one recurring concerning issue, and that relates to data localization. Data localization requires the storing of data within China. However, not all organizations are subject to data localization. The organizations subject to this requirement are those who process data by a national agency or so-called critical information infrastructure operators. Those organizations are subject to the requirements of data localization. Critical information infrastructure operators is a term of art that has yet to be further clarified. Another issue that has not been clarified is that organizations that handle personal information above a certain threshold, this undefined threshold, those organizations are also required to store data within China. So there are some data localization requirements, the specifics of which are still undefined. However, international data transfers, there are mechanisms to facilitate this under the Chinese privacy law. Notably absent is there are no adequacy decisions. No adequacy decisions. In order to transfer data outside of China, organizations will have to either undergo a security assessment organized by state cybersecurity and information departments to determine if the data must be stored locally in China or will be able to be transferred abroad. Alternatively, organizations can obtain a certification. This is similar to the requirement under the GDPR, Article 46, subsection 2, subsection 4. Alternatively, organizations can transfer data with standard contractual clauses or something similar to that under the Chinese privacy law. Finally, organizations complying with other conditions provided in laws or administrative regulations or by the state cybersecurity and information departments may transfer data abroad. Again, no adequacy decisions under the Chinese privacy law. Another similarity with the GDPR is the requirement in certain cases for data protection impact assessments. Under the Chinese privacy law, those data protection impact assessments are called personal information protection impact assessments. The Chinese privacy law requires an assessment when an organization is handling sensitive personal data, if automated decision making is used, if the data is being transferred abroad, whether in trusted personal information handling, providing of personal information, or there is a disclosure of personal information. And finally, other personal information handling activities with a major influence on individuals. So again, there is this sort of balancing test. The threats to those rights and freedoms secured to individuals under the Chinese privacy law, weighed against those safeguards implemented to ensure compliance under the regulation. There are also provisions for data breach and when those data breaches have to be notified to the supervisory authority. Under the Chinese privacy law, the supervisory authority is the Cyberspace Administration of China. They are the primary regulatory body who will also be administering clarifying documents that will help assist us in complying with the new regulation. Again, there is some opacity within the regulation. There's not complete clarity. And so we are looking forward to seeing what the Cyberspace Administration of China will have to say on some of the undefined issues. Turning to fines. The law makes distinctions between two types of violations: serious fines or serious violations and not so serious violations. What does that mean? It's not 100% clear, but the penalties are clear. In the first scenario, those not so serious violations, the authorities may order a correction. They may confiscate unlawful income as a result of a violation of the regulation and issue a warning. If the handler fails to correct the violation, it will receive a fine of up to $150,000 or 1 million RMB. Persons who are directly responsible may receive a fine between $1,500 and $15,000. So there is some personal liability tied to individuals whose organizations violate the law. In the case of serious violations, the fines go up to $7.5 million or 5% of annual revenue for the prior fiscal year. Interestingly, acts deemed illegal will be recorded and made public in the social credit system. There is a private right of action for individuals to enforce their data subject rights. So in conclusion, the Chinese privacy law has some similarities, in some sense has many similarities to the GDPR. For organizations complying already with the GDPR, adopting their compliance tools to the Chinese privacy law will not be so difficult and onerous. That is really, organizations can in some sense be thankful for that, as again, the law goes into effect on November 1st. Again, clarifications, implications, enforcement activities will likely take place further along down the road, but nonetheless, organizations have a quick turnaround time to begin complying with the law. And then turning finally to Ireland and the Data Protection Commission's fine of WhatsApp in the amount of 225 million euros. So this is the second largest fine under the GDPR, following the proposed $888 million fine issued to Amazon by the Luxembourg National Commission for Data Protection in July. The Irish Data Protection Commission fined WhatsApp on September 2nd, in particular for violating the GDPR transparency principles under Article 5 and the notice requirements under Article 13 and Articles 14. This was an investigation that was initially begun back in December of 2018. The Irish Data Protection Commission proposed a fine that was rejected by a number of other supervisory authorities. The European Data Protection Board then issued a binding decision back in July, pursuant to Article 65, requiring the Irish Data Protection Commission to up the proposed amount of the fine. So in particular, the inquiry by the Data Protection Commission focused again on the transparency requirement under Articles 5 and the requirements under Articles 13 and 14. Now, Article 14 is the privacy notice, or the notice requirement to the data subjects by the controller when it doesn't collect the data from the data subject. Article 13 is the notice requirement to the data subject when the personal information is collected directly from them. In particular, the Data Protection Commission found a number of violations, in particular under Article 13. So violations for the purposes of the processing for which the personal data is intended, as well as the legal basis for processing. the recipients and categories of recipients of the personal data, as well as the transfers of personal data to a third country, data minimization and retention requirements. The Data Protection Commission found WhatsApp failed to provide meaningful information in relation to all of these particular categories, and the list just goes on. Now, WhatsApp plans to appeal the fine, but the emphasis really is again on those Article 13, Article 14 requirements, as well as for organizations to be transparent with the data subjects about what is being done with their personal information, how it's being processed, for what purpose, under what legal basis. Like, really, these are all fundamental and easy points that organizations need to know, need to understand, need to document and provide to the data subject at the point of collection of that personal data. Now, most organizations aren't going to be subject to the potential of a fine in the amount that WhatsApp was fined. WhatsApp does have those major resources behind them of Facebook. There is, of course, Facebook is an easy and regular target for the data protection authorities. And in conjunction, so was WhatsApp, and really failing to achieve those Article 13, Article 14 requirements, and so on, which resulted again in a real eye-catching fine that highlights again that the importance of those transparency requirements, but also highlights how the supervisory authorities work together. The Irish Data Protection Commission is the lead regulator for some of the biggest technology companies in the world. Nonetheless, other supervisory authorities have a say in how these organizations are being regulated and can offer, rejections of what the lead supervisory authority did, and really kind of forcing the Irish Data Protection Commission's hand through this Article 65 process in work that we have not yet seen. And so again, another a fascinating example of the GDPR maturing over time. And with that, I'm really going to conclude this 11th edition of Soundbites. I hope you enjoyed it. I know it's really dragged on a bit in time. Covered a lot of different topics. The UK's proposals for an update to their regulation, the new Chinese regulation. Those are the big topics for this soundbite. And yeah, I hope you enjoyed it. And until next time, thanks.